All right, let's get started here with our final presentation. Will be a panel discussion of lessons learned from OSHA inspections and the next steps that I'm going to be moderating. Unfortunately, one of our panelists, Doug Fletcher, is unable to attend. He had an emergency come up, and as he informed us, he won't be able to be here. But as I mentioned, we have David Frazelle with ADM and Eric Conn. So David has worked in the grain and feed industry with ADM for 41 years. From 2013 to 2018, he held the position of Director of Environmental Health and Safety for ADM's Ag Services Business Unit. Now based in Fort Worth, Texas, he is now a Regional Health and Safety Director for ADM with responsibilities in the Southwest U.S., Mexico, Central America, and the Caribbean. David is a University of Illinois graduate and a certified safety professional. And welcome back, Eric Conn, founding partner of Conn, Maciel, Carey, and chair of the firm's National OSHA Workplace Safety Practice Group. So with that, I'm going to start off the discussion here, and I think as we've talked about here, David and Eric are open to questions, comments, feedback from the audience, so feel free to ask if you have anything. So I'm going to start right out with, what do I do when OSHA shows up at the door? So I guess maybe start out with, who do we start with, the attorney or the industry representative on that one?
Well, let me go ahead and start and just thank National Grain Feed, Jeeps, and certainly the Grain Journal. Thank you, Jess, for the invitation. Thank you, Mark, for all that you've done all these years to help our industry. And thanks for each one of you that are here. It really shows your commitment. I've greatly appreciated the discussion, the sharing that we've had yesterday, and just the care that we all have as we head towards zero, eliminate SIF incidents. And I love the discussions we've had and being proactive. Now we're going to talk a little bit differently about how we react with OSHA, and happy to share some of my experiences. And so what do you do? You know, I guess first of all, how many of you have experienced a knock on the door and OSHA is there? Just trying to get an idea. Thanks. So probably a little over a third, maybe 40%. And so I'm sure you've learned, as I have and our other managers and safety folks, some do's and don'ts. But I guess the one thing I always do is be absolutely honest. And as much as you might want to do something to this OSHA inspector, obviously we have to maintain control. And of course it ruins your day, it changes your day, especially without notice. And you really have to change that mindset. You may have all of this agenda and somehow you magically have to drop that and give OSHA their due time, because you have to be so careful as to what's said or not said. And I'll start out with one tip. I typically, there's no OSHA people here, so I typically don't try to educate them about the grain business on their visit, and so many times it's their first visit. And kind of wait and just answer their questions totally truthfully. And there may be some things that I hold back because they haven't asked for it.
Yeah, I'm disappointed, Dave, that the first thing you said wasn't call your lawyer, because that's what I would love to see as the first step anytime OSHA knocks on the door. But it depends on the circumstances. If OSHA's there on a programmed inspection as opposed to some serious incident or accident, you've got your team. Hopefully you've thought in advance about how you're going to manage an inspection, and you start to implement your inspection protocol. To me, the most important stage of an OSHA inspection is that moment from the knock on the door to the time that the inspector starts walking around your facility, and it's called the opening conference. And if you think about sort of the competing objectives that OSHA has and that you have as the employer, OSHA wants to go, these are unannounced, like Dave says. Often you may know that they're likely to come because of an incident or something like that, but if it's a programmed inspection, they're coming unannounced, totally unexpected visit. They want to get from the car to the area where employees are working as quickly as possible, because they know that hey, OSHA's here, OSHA's here. The word is getting back to the back of the house, and if people were not wearing the right PPE, probably they will be within the next 10 minutes. If they're down there doing housekeeping, emergency housekeeping, because OSHA's here, they want to get out there as quickly as possible. Maybe our objective is to slow that process down a little bit. It's not the worst thing in the world that everybody knows that OSHA is there, and I'm sure they're always following your policies, but give them an opportunity to really double check and get that low-hanging fruit. The other reason the opening conference is so important is it's your last chance. It's your last chance to cut off the inspection before it starts. I've had OSHA show up more than a few times to do an inspection under an emphasis program that doesn't apply to my industry or my workplace, or under these emphasis programs, if you've had inspections in recent years, you're supposed to be exempt from a new inspection. So that's one of the first things I do is I check to say, all right, why are you here? What's the intent of your inspection? What's the scope of the inspection? And then based on what they tell me, I'm gonna evaluate, does OSHA have a right to be there? And if not, don't slam the door in their face, but you have a respectful discussion with them. And I usually say, I always understood that if I've been inspected within the last 3 years, that I'm not supposed to be on the list. And I'm looking at your website, OSHA, and it says that, we had an inspection 2 years ago. Oh, well, let me call my office and check on that. You do it respectfully, but you don't miss that opportunity. The second thing, and that's rare that you're actually going to avoid the inspection altogether, but what's much more likely is you can control the scope of the inspection. Are they there on an employee complaint? What's the subject of the complaint? You're entitled to see a copy of that complaint. And if the complaint is very narrow, you can try to negotiate with OSHA to make sure that their inspection stays narrow. I've had situations where OSHA was out there because somebody complained about an unsafe condition on a forklift. And we said, okay, OSHA, you stay here in the parking lot. And we drove the forklift out to the parking lot and said, hey, have at it. You can see records about our forklift training. Here's the forklift. No reason for us to go into the facility. And they know what you're doing, but that's okay. That's why they're there, and they will keep it limited like that. With active emphasis programs, it's harder because they've got a built-in excuse to go broader than an employee complaint. But don't miss that opportunity to use the opening conference to negotiate respectfully with OSHA about what their purpose is and what the scope is. And all the while you're having that negotiation, sitting down in a conference room in the front office, hopefully some low-hanging fruit is actually being addressed in the back.
And the thing about the scope, and that's so important, is, and don't be afraid to yourselves or guide your managers, your superintendents, to kind of gently nudge them when they start to go beyond that. Of course, anything they see would be fair game, especially if you're going out to an incident scene, or maybe it's more of a broader inspection. But you want to instruct, or if you are a manager, superintendent, don't be afraid to remind them 2 hours, 3 hours later when they start to veer off. And maybe it's about a totally different subject matter. And just say, well, we talked about that scope.
That's right.
At the beginning. Are we going beyond that? And of course, usually I do call the attorney with ADM right away before as we're checking credentials and some other things. And I've been known to request the plant just to shut down too. There's nothing that says that you have to continue running while OSHA's there.
And there may be really legitimate reasons for that, right? OSHA looking over people's shoulder makes people antsy and makes people make mistakes. And from a true safety perspective, you're not hiding something, you're not intending to hide something from OSHA, but they're going to want to interview people. You're going to need people pulling records, pulling equipment for OSHA to look at. And I think people make mistakes when OSHA's looking over their shoulders.
Well, and not many of us have an extra, $136,532 laying around, and so you always want to minimize your exposure, just like we do in safety every day, trying to identify the hazard, reduce the risk, and do that job safely.
So quick question on the scope that I wanted to ask. So on the scope, as you were talking about earlier with COVID-19 and the National Emphasis Program, so OSHA could come to your facility, they're saying, hey, as part of the Region 7 regional emphasis program on grain handling facilities, we're coming in here to do an inspection based on that. However, if they were to walk into the office and don't see hand sanitizer or any signs, they could say, oh, and we're also going to be doing an inspection based on the COVID-19 NEP. Is that possible?
It is. So there are emphasis programs that explicitly talk about how you expand the scope, and then there are circumstances where I think what Dave was talking about before is this idea of plain view. If OSHA observes a hazard, a condition, an operation that doesn't seem quite right in plain view from a place they're allowed to be, which means I've allowed them into my workplace to do a grain inspection, and they observe, and this is going to be tough now because of the distinction between vaccinated and non-vaccinated individuals, but if they come in and say, I don't see a single person here wearing a mask, so I'm going to do an inspection about COVID, even if your answer is, hey, everybody's vaccinated, or everybody told me they're vaccinated, or they've indicated that they're vaccinated because they took their mask off, well, OSHA's probably still going to try really hard to expand that scope and dig into that. And we know, OSHA's going to tell you we don't have quotas, but they have quotas. Right? They are expected to do a certain number of grain emphasis program inspections every fiscal year, and we know they're expected to do a ton of COVID inspections every year. And OSHA's favorite thing to do is to kill a few birds with one stone. So if they can come into your workplace and do a grain emphasis program inspection and a COVID inspection and whatever else other emphasis programs they have, at site-specific targeting, whatever, they're going to love to be able to check all those boxes so that they can say, we met our not quota this year. The other thing I wanted to add, though, about that the first moments of the inspection is who is going to be your inspection representative. And we very often will have clients who arrange to have their corporate safety manager is going to be the OSHA inspection representative, the person who is walking side by side with the OSHA inspector during the visit. And it is pretty rare in an industry like yours with a bunch of elevators spread around a few states that your corporate safety representative happens to be at that elevator when OSHA shows up. So you have a right to be represented during an OSHA inspection. And if OSHA shows up and says, we're ready to get started, and you say, listen, our company policy is my corporate safety director is going to be the site inspection representative, and he's not here, but he can be here within the next 2, 3, 4 hours, I would stick by that. If that really is your policy, assert that expectation with OSHA and say, listen, I'm not playing a game with you and I'm not trying to interfere with your job, but we want our corporate safety rep here for OSHA inspections, and he can't be here for whatever, 2, 3 hours. OSHA will wait, according to its field operations manual, a reasonable amount of time for the company's inspection representative to be present. They say in their field operations manual that a reasonable amount of time is 1 to 2 hours. To me, that's bogus. A reasonable amount of time is a reasonable amount of time. It's how far away is the individual and how reasonable is your request. Are you doing it for a nefarious reason, or are you doing it because it's your right to be represented? And we've had plenty of arguments with OSHA about how long they will wait, but at the end of the day, if they say, well, we're not waiting, we insist, remember that you do have that right in your back pocket to say, well, I need an inspection warrant before I'm going to let you come in here. And I don't want to do that. I want to help you do your job, OSHA. All we're asking is that our safety rep be here for the inspection. So can you come back after lunch? Can you come back tomorrow morning? And at the end of the day, it's going to take them several days to get a warrant. So usually you can negotiate that and make that work. The one thing I will try to do is to accommodate OSHA a little bit, is to say, let's do the opening conference with my safety rep, my safety director by telephone while he's traveling here, or to get him started, and we'll share some documents with you while you wait, but we're not going to go walking around the facility until he gets here. So you show him that you're willing to cooperate a little bit, but you assert that right. If you've got a specific person, company lawyer, company safety director, operations manager, whoever it is, assert that right, because, like Dave said, this is consequential, and you want to make sure you're putting your best foot forward and you've got the right person leading that process. Make OSHA wait if that person's not ready or not present.
And I think having that documented, whether it's an operating procedure or a policy, so you can really train, that new superintendent or assistant superintendent or whoever you have at your facilities to really be prepared. And one of the things we always do once OSHA shows up is to have that conversation about, how you answer questions. And if there's a long, drawn-out question, we'd prefer short, direct questions. And don't be afraid to train your people to, can you clarify? Can you be more specific? Because that first impression is going to be so critical. And there are a number of things. Of course, we have to produce our OSHA logs, our 300 days, very quickly. You'd want to provide them an orientation before they go out into your facility. And so there's a number of things to talk about.
Well, I think this is great. This is a good dialogue on with OSHA coming to the door, kind of the initial part, but I think another really big part of this too is kind of the post-inspection, right? So, I mean, they've come to the door and we've talked about the scope and the process and everything, but I think the post-inspection process or during the inspection, I mean, those are big factors as well. Like, for example, what if you have contractors working at your facility? How do you handle that? And the difference, with the employee interview, salary versus hourly versus, non-English speaking. I mean, there's a lot of those factors that are part of that. So I guess maybe they've come to the door, we've kind of gone through that process, so maybe could go through a little bit about the inspection process, some of those questions, and then we can kind of go to the post. So I guess who wants to take the first stab at that?
I'll talk a little bit about that. There's really three major in-process stages of the OSHA inspection. There's the document requests, the interviews, and the walk-around inspection. And I'll say just a little bit about each of those. For document and information requests, Dave talked about sort of that first record that they're going to ask for is the 300 log. And the 300 log and the 300-day annual summary are the only documents. I want to make sure I check myself there. I believe those are the only documents that OSHA can ask for that has a deadline or a time limit for you to produce them. There's a few other things like employee medical records that are sort of separate from inspections. So in an inspection, those 300 logs have to be produced, I think it's within 4 hours, 4 business hours of the request. And OSHA is not usually too nitpicky about that, but the idea is they don't want you creating the logs overnight, lining things out of the logs overnight and taking your time. You got to get that document to them quickly. But that's it. Everything else, even if they say in their handwritten document request, I want these by tomorrow, or I want these before I leave today. Well, that's nice that you want that, but we're not required to do that, and I'm going to take my time. The document requests, I think you want to be very careful with. You want to ask OSHA to put their requests in writing, except for that 300 log. Everything else they should put in writing. I usually say, look, it doesn't have to be formal, doesn't have to be fancy. You can handwrite it, but I like to have it in writing so nothing falls through the cracks. We get you what you need. But it also gives us a chance to parse what they're asking for, and most importantly, I don't know any of you have had this experience. You're walking around with an inspector, and he is just rattling off all these things that he wants. Oh, I didn't realize you had forklifts. Give me your forklift training and forklift maintenance records. Oh, would you look at that? I didn't realize you had this kind of equipment. You've got milled machines. Let's get some preventive maintenance about that. Oh, I didn't realize you had this kind of electrical installation. Give me some records. But no problem. Just get it to me in writing, and we'll get you what you need. The written request you get from OSHA is about 10% of all the things he was talking about he wanted to see during the walk-around. And I'm only going to respond to the things that he gives me in writing. So ask him to put it in writing, take your time with it, review it, be careful with it. You want to talk some about that?
The only other thing I would say about that document request, and about half the time it's really nice where OSHA has that sheet of paper ready to go. Obviously you're going to triple check things that you're going to provide OSHA, and then make a copy for your file. You want to know what they know and other people that are going to come and help you perhaps later as maybe a citation comes. What does OSHA know? And even though we're very proactive our safety, I'm going to be very defensive with OSHA, and I'm going to be very protective of the company, and just really double check that.
Yep. And then in terms of interviews, Jess mentioned there is a distinction in the law between employers' right of representation during interviews involving supervisors and non-supervisors. And that is an important distinction. If any of you have responsibilities that involve kind of HR and employment-related categories, in almost every other category of law, the distinction is management and non-management, and it really matters whether you can hire and fire and really exercise management control. In the OSHA context, it's supervisors and non-supervisors. So you might have somebody who is paid by the hour who you don't think of as management at all, but if that person is sort of a lead or a foreman, or somebody that gives assignments to others and oversees their work, even if they can't hire, fire, discipline, or control, they can still be considered a supervisor. And the significance is supervisory employees, their knowledge, their statements, their admissions are imputed to the company. So it's like ADM is sitting in the chair when your elevator manager is sitting in the chair answering questions. And if he says, oh yeah, we knew that housekeeping was a disaster down there, but we had to get that train out. Oh my gosh, the company just admitted to a willful housekeeping violation, and that's no good. So when that supervisor is being interviewed, the company has a right to be present because it's as though the company is testifying. So the company has a right to have a lawyer present, another manager present, the safety director present to represent the company during that interview. Conversely, for a non-supervisor, and this is where you get often some big fights with OSHA, non-supervisory employees have a right to a private interview with OSHA. OSHA tries to co-opt that right and say, well, that's OSHA's right. OSHA thinks they have a right to privately interview non-supervisor employees. That's not actually true. It's the employee's right to have a private interview with OSHA, and that employee can waive that right. That is going to create a fight with OSHA because OSHA does not want you in the room because they believe that the mere presence of intimidating folks like us will keep employees from being truthful with OSHA. So if the employee says they want you in the room and you say, okay, I'm going to be there for that, OSHA might leave and go get a subpoena. They might threaten to get a subpoena and say, we're going to bring a lawyer down here. We're going to do this as a deposition to scare that employee into having a private interview. But it is the employee's right. I try not to have that fight with OSHA if I can avoid it, but if it's a serious accident case, certainly if it's a fatality case, and the employee wants a representative in there, company's lawyer, his own lawyer, a union representative, a manager, whoever, the employee does have that right, and that's something that we tend to fight with OSHA about more than we need to.
And I think as we all know, we have a requirement to notify OSHA of an injury. I think when it's a serious injury, there also needs to be a discussion about the effect of that injury, that pain and suffering that a coworker is going through, and whether or not OSHA is sensitive in discussing perhaps a coworker that has seen something horrific happen. So there's a lot to discuss before those interviews take place and try to draw those lines as much as you can.
Yeah. Well, those are good points. Is there just curious, any questions, comments from the audience so far? If you have anything, feel free. Oh, Jay. Are you just going to throw it across? Okay. Well, good. Well, we can keep on going. I know, that's very good. So we've talked about when OSHA comes to the door, we're talking about the process, Oh, I'm sorry. Was there a question? Oh, okay.
Related to interviews, can you discuss what information an employee is required to know and have answers to versus what they can simply say, I'm not certain or I'm not sure?
Yeah, that's one of the first bits of advice that I give to non-supervisory and supervisory employees going into an OSHA interview is that you're not expected to know everything. And the reality is you only know what you know. Even if you're supposed to know, so even if we were supposed to train you about something, if you don't know it, the right answer is, I don't know. I don't know, I don't remember, are totally acceptable. One of the things in that regard, though, that I think is really important, and a lot of people are afraid to do, a lot of employers think, this guy's going to go talk to OSHA, I've got to just be hands off and let this whole thing happen, and that's fine. I think there is absolutely nothing wrong with preparing witnesses, supervisory or non-supervisory, preparing them for an OSHA interview. And that means two things to me. One is I talk about their rights with them. I try to make them more comfortable going into the process, because nobody likes to sit down with a federal agent, and that's what this is. So you talk about, your rights in those interviews. It's a voluntary interview. You've got a right to take a break anytime you want. You've got a right to obviously say, I don't know, I don't remember, if that's a truthful answer. You've got a right to have a representative if you want one. You don't have to sign a statement. You don't have to be recorded, video or audio recorded, if you don't want to. And then the other side of that preparation is substantive preparation. Generally, by the time you get to interviews, as the employer, what is OSHA digging around at, right? Are they here because of an incident involving, whatever, an explosion? Are they here because of a forklift incident? Whatever it is, we know substantively what OSHA's digging into. Or if it's just a grain emphasis program inspection, we know what they're looking at for that too. So I'm going to refresh my employees' recollections about our programs. I'm not going to teach them anything new, and you're not going to put words in their mouth, but you're going to say, hey, remember when we trained on bin entry 2 months ago? This is your signature, right? You were at that training event. Remember when we talked about this process? There's nothing wrong with reminding them about what your policies are, so that they sound, fresh and knowledgeable about those subjects when they sit down with OSHA. That's okay to do.
Yeah, I think that's really absolutely critical. You can imagine how nervous anybody could be, especially a new employee or even the most seasoned employee, and we do the same thing and totally on the same page.
And Jim, I think you had a question?
Yeah, just on this subject of interviews, when OSHA's out in the facility walking around, oftentimes they will interact with employees. So I don't know, do you have any advice on how to deal with that on the interview process?
Yeah, do you want the stop and talk interview?
Yeah, that certainly comes up occasionally, but I guess also shutting down the facility, we kind of remove colleagues and contractors from the areas too, but it still happens. And, that's where you could walk up to them and state, is this someone that you're going to want to interview later? You can try to lead into a conversation that's going to delay that, because you wouldn't want to have not, prepped someone, right? And so they may walk around first. So there's ways to gently kind of intercede, but you have to be thinking about that as a manager ahead of time, right? And really, okay, I've got, this guideline to follow, but great point to be careful of.
Yeah, well, what we would typically do is exactly that, is I'll allow the 1 minute, orientation type, hey, what is this machine? Just so that, if he wants to ask an operator what he's working on, I'll give him about a minute. And if it looks like he's really interviewing the guy rather than just orienting himself, I'll jump in there and say exactly like Dave did. If this is somebody you want to interview, no problem. Let's just get that arranged. I don't think right here on the floor is the right place to do it for safety reasons. We've got a room set up for you, OSHA, where we can bring this fella down for an interview. Just let us know. But he's in the middle of doing his job right now, and for safety reasons, we prefer to do these interviews in an office rather than right here at the machine.
And I think we have a question.
Yeah, I was just going to ask, what's the importance of having that conversation with the colleagues, so if they don't know an answer, not just making an assumption or, I guess, a best guess judgment on what they think the answer should be?
Yeah, I think you just want to avoid guessing and speculation, because if you don't know, there's as good a chance you're going to give the wrong answer as the right one if you're just guessing. And the idea is that, there's a whole puzzle there to be filled in, and everybody's got their own pieces of that puzzle to fill in. And if it's just not, this is my maintenance guy, so he doesn't know anything about rail car loading, he shouldn't be guessing and trying to answer questions about that, because it's just not part of his ordinary job. And you don't want him saying something that OSHA's going to run with. If they hear it's gospel now, and they're out there they're not there to give you awards, they're there to find things that are wrong. And if somebody says something that sounds like a violation, even if they don't really know what they're talking about, OSHA's going to run with that, and you're going to be dealing with it for months defending a citation rather than a couple of hours during an inspection.
Now, and just also as far as I know we're talking here federal OSHA. Now, is there any difference with a state plan state, or is the process, everything we're discussing here, the process pretty much the same? So, for example, we're here in Nebraska. You could have a facility in Nebraska. You go across, the river, and you're in Iowa, which is a state plan state.
There's not a lot of huge differences. I mean, there's some nuance, and California always has to be special, so they do things a little differently. They won't share employee complaints with you like they do in every other jurisdiction, but by and large, they all operate pretty similarly in terms of participating in non-management interviews and document requests. I don't know if you run into any real nuances.
I think the only thing difference is here in Omaha, the OSHA office certainly has a lot of awards on their wall. If you've been to an informal conference there, it's amazing, the plaques. So I know they don't have quotas, as you say, but no, not much other difference.
Yeah.
Good. Well, I know one thing, going through the whole process here. So, OSHA's come to the door. You've kind of gone through that. Talking about the interviews, with the management, non-management. What do you do then? Like we're talking about, I think you referred to it, Dave, when you're, if you wanted to shut your facility down and you wanted to send your contractors home, and that's kind of my question was regarding contractors. Like, what if you have contractors at your facility doing work and then OSHA comes and, how does that usually handled? What if they're walking around maybe before if they're not sent home or they're how does that process work?
Yeah, I mean, it may be that they're there to see and talk to the contractor.
Right.
Mm-hmm. And so where you have these multiple employer sites, it gets to be tricky. They tend to always want to just talk to ADM, but I don't know, somehow they think we have deep pockets. My pockets are empty. I don't know.
Yeah, I mean, there are some programs, some of these emphasis programs that will say if there is a contractor or a temporary employee or something like that on site, that OSHA is obliged to open an inspection of each employer. And you see that a lot in the grain inspections and other, sort of petroleum refineries and chemical manufacturing sites, where they're going to open an inspection of every contractor that they're aware of that's on site and inspect them separately and individually. If you've got people who are on site who are maybe technically contractors, but you're supervising them on a day-to-day basis, OSHA is going to look to you as the responsible attorney for safety and health for those individuals. That happens most often when you've got temporary workers through a staffing agency, but the staffing agency doesn't have on-site management. You're their employer for OSHA purposes, even though somebody else is giving them the paycheck, managing their benefits, managing their sort of HR piece of this. OSHA is going to look to you as the employer for that. So those folks are, going to be considered like your employees for an inspection or potential enforcement.
Yeah, and that's what I was kind of thinking of with fall harvest coming up, and you have a lot of the temp workers
Right.
that are at the facilities during harvest. I mean, that's what I was kind of thinking, Dave. How does that, how would that be handled at one of your facilities if you had one of those regional emphasis program inspections and you have the temp workers there? It's busy as can be. You can't shut it down, right? You're not going to be shutting down the facility during harvest, right?
Sure. Well, and what's interesting, of course, we're supervising people, then, it's going to be fair game. But I think you owe it to the temp service to notify them if you're in that position. And they may have an objection to OSHA interviewing their employees, believe it or not. So you run into a lot of different issues to work through, but,
And I mean, OSHA's, you're not going to nobody's going to twist their arm to dig into that temporary worker issue. OSHA loves that issue, right? We talked about it earlier this morning that OSHA views that as a vulnerable population. They think that employers bring in temp workers in a lot of respects to avoid safety and health obligations. Well, it's not my employee, so I'm not going to train them. It's not my employee, so I'm not going to, I'm going to put them in the dirtiest, most dangerous jobs. So OSHA gets excited when they hear that these other employers are present on site and that these temporary workers are on site, and they're going to want to go out of their way to dig into that issue. So it's not going to be an afterthought for OSHA. That's going to become an exciting and prominent part of their inspection in all likelihood.
So any other questions? We've talked about kind of I guess you could say when OSHA shows up at the door, part of the inspection interview process. I think it might be good to move to the post-inspection. So one more, okay.
I was just going to ask, so say you do have contractors on site and you assign a lead contractor basically, or a supervisory contractor to manage the other contractors that are on site. How does that work with OSHA as far as, if they see these contractors making a violation, but they're reporting to their supervisor, which that supervisor then reports to that company, I guess?
Yeah, I mean, that's one of the most complicated situations in the OSHA framework is this multi-employer worksite issue. And OSHA is going to analyze that and look at whether you as the host employer, how much control do you actually have over safety for these other entities. And what you're describing is very different than kind of the temp worker. This is a real, an organization out there. Maybe they're doing a construction project for you, or maybe they're providing some specific service, and they're specialists in that field. OSHA is going to analyze every one of those situations on a case-by-case basis, and they want to cite as many people as they can. And under the multi-employer policy, they can cite the contractor as what they call the exposing employer. They're exposing their own employees to a hazard, but they could look at you as the host employer and say you ultimately control safety at your site, at your workplace, and you have a role relative to those contractors. They may look at it and say, well, this is a very discrete specialty contractor, doing work on your HVAC system, and you don't really have any interaction or control, and maybe they'll just focus there. But they're going to be looking for every opportunity to say, oh, we've got 4 employers, we can write one citation and spread it around to 4 different people. That helps us with our numbers too. So they'll be looking for that opportunity.
You had a quick question. We've had an opportunity to have Region 7 come and visit us, and they brought 3 folks. 2 of them are training.
Yeah.
Do we have do we have to have all 6 ears in every single walkthrough, every single interview? Do we have some recourse to say, hey, us 2 and 1 or 2 of you, but not all 3 crammed in here
It's
together? That's
hands-on
6
training.
ears.
Right.
Pardon?
It's hands-on training for
Yeah,
OSHA,
it's
right?
definitely hands-on training.
OTJ.
But I think, as Eric talked about earlier today, with the budget increase and just changes, we're seeing a lot of new people. I've been involved in 2 OSHA visits this year, and in both cases, there was a trainee, a new person. And I think as we get into citations and informal conferences and contest, I think we'll talk a little bit more about the importance of that. But you need probably more than one person in an agreement on how you're going to stay together as a group. And we go up in the Texas house, how do we get there? How do the other 2 stay behind? So there's a lot to work out. And going back to something Eric said is if there's 3 people that show up, you may want that safety director there to help, and that might be a way to justify that a little bit too. But I still would be hesitant to educate them too much.
Yeah. Yeah, I mean, we are seeing tons of trainees out in the field right now, and you would be hard pressed, I think. I mean, the idea would be if we say we're not going to allow all 3 of these people on site, OSHA may go get a warrant, and I think you'd have a really hard sell to a judge that there's something too burdensome to you. If they are just trainees and they're shadowing and they're sticking around, it'd be a tough argument to make to a judge. But the OSHA has to be reasonable. The OSHA Act says reasonable inspections at reasonable times and reasonable conditions. And if at some point they've got enough people piled on you that you're not able to adequately represent yourself, then it might be a reasonable opportunity to push back. But I mean, we're going to see that circumstance everywhere for a while now. Tons of new people out in the field.
Yep. And there's a question.
So I know OSHA had a program targeted for small and medium-sized businesses, at least, about voluntary assessments that a consulting group would come out. I just would be curious as to thoughts of, is it ever a good idea to invite them in even for voluntary assessment, knowing that there's supposed to be confidentiality, because I think it could apply to some in the room.
Yeah, the consultation program. It's a great question. So there is technically under OSHA's banner the enforcement side of the agency and the consultation side of the agency, and there is supposed to be a wall between them, and there generally is a wall between them. They ordinarily will not talk to each other, except if consultation program comes out, does an audit for you, makes recommendations, and they feel like you have not adequately addressed their recommendations, and the recommendations are compliance-based recommendations, right? We don't think you've implemented a compliant housekeeping program. We recommend you make these few changes, create these logs, do the cleaning on this frequency, and you thumb your nose at them, or you write back and you do something different than what they asked for. They'll keep pushing you for a while, but eventually they will refer to the enforcement side of OSHA. So there is a risk there if you're not willing to really address their recommendations, and that's hard to determine whether you're able to do that before you know what the recommendations are. So to me, there's some risk doing it, but for really small employers, I don't ever want to say, it's a terrible idea, don't ever do it, because if you don't really have the resources to bring in a consultant, you don't really have the resources to have your own sort of internal safety department or even a single, safety manager at the company. It is it is a free resource from, the agency that's your regulator, so you're going to get a pretty good sense of whether your status of compliance, and they will provide you with useful guidance. I mean, they're good, smart, good, genuine safety people, but there is a little bit of risk there. So I always say, if you can afford to bring in your own consultant, you can afford to bring in your own safety guy, safety team, I much prefer that over the consultation program, but it is a good resource for really small employers that just don't have that internal bandwidth.
Well, why don't we move to the next step here? So as we said, we've talked about the inspections, the opening conference, the inspection itself. So what's the next step then if you receive a citation, right? So they've come through, they've done the inspection, and exactly 6 months to the date of the inspection, you then receive the repeat violation citation. And so what's the next step from there?
Well, it's interesting. You said 6 months to the date. What happens if it's 6 months and 5 days? We could go into those details, but they're certainly within the Act and within a lot of other OSHA's guidance that it really has to be received. You'd have to receive it within 6 months of it being discovered or the occurrence of the hazard. And that's really key. It might get you off or at least give you a bargaining chip if that's the case. But you've received that envelope and you're starting to open that up. I always tend to go to the summary page at the end and see how bad it is first. But those of you that are presidents, vice presidents, owners of companies, you might want to be maybe reserved a little bit until you've not only read the citation, but then had that first meeting and, where are we at? Because what I'd like to share a little bit about receiving that citation and the informal conference is, many times with these inexperienced OSHA people or people, we recently had a visit, a 25-year OSHA person that had never been in a grain elevator before. So a lot of times, well, I'll put it this way, there's chance for error. So it might get pretty exciting, unfortunately, to see $136,000 or a couple of $13,000 citations, but show some reserve until you figure out within your organization where we stand. And what I would say is, and I'm not an attorney, I'm not a defense attorney, but I certainly play that role. I've stayed in way too many Holiday Inns over the years, and I want to defend my company. And, what I used to like in going to an informal conference was when the assistant area director or the area director, if we were lucky, would say, and we hope to, come to an agreement today. And I would tell you that's what I was looking for 5 to 10 years ago. But I'm not willing to get an agreement over a citation that we are not in violation of. And so you get the citation, of course you have to post it and all that stuff, and I think for the sake of time, we'll skip some of those preliminaries. Read it and read every word and follow those instructions. But now you have the citation. And now it's game on. What have you done all these years, especially if it's a 272? We've had 1910 272 for 33 years, and you all have helped to shape our approach in being not only in compliance. I look at that as the floor. I want to come way above so I don't have injuries, and we're all there, right? So what have you been doing, and what do you have to defend yourself? That's really a huge key. Yeah, and one last thing real quick. You know, we received a citation in Kansas at one of our elevators. We have a few in Kansas. And, you know, they cited 272J2, priority housekeeping area, in a boot pit that was an outside leg, and only 10 foot 3 inches was in the ground as a 100 and some foot leg. So it was not an inside bucket elevator, and 272J2 doesn't apply. Please don't take a citation that, you know, have principle, try to convince your organization, your leadership, you know, give in on the ones that you may not be compliant with, but then fight on the ones that you're absolutely in compliant. And I can tell you, I'm one of the few safety people, and I had the help of a great attorney to go against this office in Omaha in a bad situation, but they were giving us a citation that did not apply. We were not in violation of, and we took it all the way before a federal judge. And I loved some of the words of that judge when we were finishing up, and we had to wait for the decision, but we won. So that's all a lot easier when you're talking about $130,000 today, but call your attorney.
Yeah, I mean, that's the answer to all these questions, is call your attorney. You asked the question, Jess, about the repeat citation, and that's the obvious one, right? This is a big deal. We've got to deal with this. There's a thing out there called the Severe Violator Enforcement Program that has swept a lot of grain employers into with multiple repeats and willfuls. The tougher question is, what do you do when it's not a repeat violation? What do you do when it's 2 or 3 little serious citations and one other than serious? The total penalty is less than $25,000, and OSHA offers you right out of the gate, we'll cut the penalty down to $7,000, just accept these 4 citations. I mean, this is what I was talking about this morning. To me, it fundamentally changed the way I practice law, and that's what Dave was talking about, fundamentally changed the way that ADM manages their OSHA docket, is that every one of those citations, even if it's other than serious, even if it's a $0 penalty, is a target on your back. Now, if it's a citation about, you know, not having toilet paper in the bathroom, maybe that's really not a big deal, and that's not something you're going to be too concerned about having on your record. But if it's a 272 violation, even if it's other than serious, even if it's a $0 penalty, well, how many opportunities are you going to have to trip over that same standard again? Like 10,000 every day at every one of your facilities? There's always an opportunity to get tripped up on that standard again. So to me, we are digging in and fighting on the standards, violations that allege, or citations that allege violations of standards that are at the core of our business. You just can't have those on your record anymore because of the likelihood they turn into repeats or willfuls. And, you know, sometimes it's not even about whether they've got you dead to rights, right? And to me, that circumstance doesn't exist. But even if they've got a picture of the dust that is, you know, 4 inches deep in a particular location, that's not necessarily a violation, right? It could be a spill as opposed to fugitive dust. It could be, you know, in a discrete location as opposed to representative of the entire area. It could be employee misconduct. It could be an area that, you know, you just inspected a little bit ago and there was no violation at the time, so you don't have employer knowledge. The idea that there might be a technical violation does not mean that there is a valid citation. And even if there is just literally no defense that we can even get creative and come up with, that doesn't mean you can't negotiate with OSHA. One of the things that we have started to do, we're having a lot of success with OSHA on this front, is that they don't really care that much about which standard is ultimately cited. If they want to have affirmed citations and they want to collect some penalty and they want abatement, and generally speaking, I mean, these are not bad people. In fact, most of them are really drank the Kool-Aid. All they care about is safety. Some of them are pains in the butt, but mostly they care about safety. So if you can go in there and negotiate with them and say, here's 5 things that we as a company are willing to do that your standards don't require us to do, that even if we went to court and you won and the citation was affirmed, we wouldn't be required to do, but it's going to have this profound impact on safety at the workplace. We will do those things for you. Write them into the settlement agreement. We'll commit to do them if you withdraw this item, or if you rewrite this item to cite a standard we don't care about. Things like that. And you know, the best situation, like Dave talked about, are the ones where OSHA's got it wrong. You go in there and demonstrate that. But the ones that are tougher calls, doesn't mean you necessarily need to lay down and take it. There's opportunities. You can get leverage from being legally right, and you can get leverage from promoting a safety enhancement that OSHA couldn't otherwise require. And that's been a great strategy we've had success with lately.
Well, the situation where we were cited in an outside bucket elevator boot pit was 1/4 of an inch of dust, and it had been cleaned the day before, and we had good aspiration on that leg, and we basically would go down in there every day, and but yet it wasn't. Now, I was working with one of our locations in California, and you mentioned California earlier today. What was quite interesting about that informal conference is I argued that they totally had the wrong chapter and verse down on paper. The manager, they don't call them area directors there often, the manager got the judge on the phone, said, we're not dropping citations, are we? No. And then the judge went on and on about the last one that got dropped, and the commission panel was attacking them. Once they see that amount of money that's coming in, and basically I had the judge on the phone and the manager there as I was in their office. What chapter and verse do you want us to cite you on?
Instead, yeah.
So you kind of have to be careful in some of the things, but and Jess and I have talked, and others with ADM with Jess, about a citation we received at one of our locations where they stated under 1910-132 we didn't do a hazard assessment properly because we didn't require flame-resistant clothing of our workers. And then the other thing was a flour mill, and again back to 272J2 Roman numeral 2, we weren't addressing priority areas. Well, OSHA's own guidance, they say they're going to train people before they go into a grain handling facility, and there's a CPL 02, 01, 004, and it states right in there that priority housekeeping areas for a grain elevator, not a mill. So you are going to see, especially over the next several years, OSHA inspectors that not only don't know 272, they are having trouble getting up to speed on other 1910 standards. And in this state-ran location, we were having trouble having even a conversation with them. And so we just went to contest right away. And then we took it to a higher level to people that have more years of experience, and they say, oh yeah, that doesn't fly. And both citations were deleted. And so it really depends who you're talking to in an informal conference, whether it's that experienced area director or someone that's been put in that position that doesn't have the experience. If you have 10 years of working with OSHA regulations and experience in your facilities, and you've been paying attention to these meetings over the years and other information, you probably know more. And so I think we have to be real careful in these informals. And then about contests. So, when would you contest a citation?
Yeah, and I would say it's not just experience level and knowledge. There is just some real value in getting one step removed from the guy whose name is on the citation, right? Remember that, if any of you have had this experience, what an informal conference is, a citation has been issued, you've got about 3 weeks to go have this settlement negotiation with the area office. And it is usually you're sitting across the table from the guy whose signature is on the citation. and it's still wet, right? He just issued the citation 3 weeks ago, and you're trying to tell him, you totally blew it, this is all wrong, withdraw the citation. That guy is going to be a little defensive about that, and his compliance officer, who's hiding in the room, right next to where you're meeting with him, are super defensive about it. And whether they're right or wrong, they're not likely to admit it, and it's really early in the process, and it's not the best audience. So there are times that we don't do an informal conference at all. I usually will do it because it's at least an opportunity to gather some information from the agency. What's their position? What facts do they know about that we don't know they know about from private interviews, for example? But a lot of folks out there, a lot of employers are afraid to file that notice of contest. They think, I file a notice of contest, that means I'm going to court. That means I'm spending tons of money on a lawyer. That's not the case. Notice of contest itself is maybe a paragraph that just says, you don't have to put anything substantive in there. You just say, we are contesting all citations, characterizations, and penalties. That's it. And then you're going to have probably 1.5 to 2 years before there's a hearing. And during that entire period of time, you've got lots and lots and lots of really good opportunity to resolve the citations. And to resolve it maybe even a month after the notice of contest, but you're going to be talking to a different person than the one who signed the citation. And a lot of people think, well, isn't that person going to be a lawyer for OSHA, somebody in the solicitor's office? And everybody hates lawyers, I get it, but it's often a better audience when you're talking to OSHA's lawyer because they get it. It's going to be their job to prove this to a judge. And if they're looking at the file, they're a lot less of the drink the Kool-Aid guys in the solicitor's office that say, well, this was an unsafe situation, we're gonna cite something. Instead, you're gonna get a lawyer that looks at it and says, I think I'm gonna lose this case if I take it before an ALJ, so I'm gonna have a more reasonable discussion with the employer. So getting past that, notice of contest, still lots of opportunity to negotiate, and frankly, in a lot of cases, it's with a better audience.
And gentlemen, I know we just have a few minutes left here, and I was just going to say just 2 points there from what Eric was saying. From the industry standpoint, right? So a lot of the issues, questions that we'll get from NGFA members is like, well, this boot pit related citation, it's only $2,500. What should I do? Just pay it? And I'm like, well, think about what that means for the rest of the industry, right? Because if you were to take that penalty and then OSHA, what would they do? They could go to the grain elevator next door, which could be you, and saying, hey, this facility right next door, we cited for them, and they've already admitted that was that boot pit should have been a permanent confined space. So why isn't it for you? And as Eric was saying too, many of these cases revolving around rolling stock fall protection and permanent required confined space, he's been involved with, working with many of our members in different states, and exactly what he said. They contested those citations. It got to the point where it was talking with the attorneys within OSHA, and guess what? Those charges, or I should say, those citations were dropped, right?
Yeah.
So I think that's a key point to raise.
And a lot of those citations were small dollar citations. Yep. But what's not small dollar is, well, now I've got to do a permit entry every time I go into a boot pit, which I'm going into multiple times every day. Or I'm not allowed to get inside of a bin with a sweep auger. I've got to go buy all these, zero entry sweeps, and that's millions of dollars. So the penalty amount, I get it. It's, we're in business to make money, so you're looking at the penalty. But penalty is often third, fourth, or fifth most important thing about a citation. What am I going to be required to do to abate this? Does it create the potential for those $137,000 repeat violations? And what is the precedent that I'm setting for my company or the industry? All have to be considered when you see those citations. Think about that.
And I know we're about to wrap up, so one final question, gentlemen, that I think is a very important issue is OSHA and their drone policy, right? I think, many of the companies are either have a drone policy or in the process of developing one, or may not have one, but OSHA has been using drones in inspections, and I think, as I understand, they've been used in after incidents, doing investigations, but just kind of want to get your thoughts on that. I guess we can start with you, Eric, on that.
Yeah, in 2018, OSHA introduced a drone policy. So there is a document on OSHA's website that lays out the parameters for when they can use, an unmanned aircraft to fly around your facility and take video and photographs. They've not done a ton of these at this point, but almost every one that I can think of where OSHA has used a drone has been in your industry. And it has generally been in the context, as Jess said, after some very significant incident where it is physically unsafe to, after an explosion, and you haven't established the stability of the structure. OSHA will use drones to go fly into the elevator and get as much video as they can to assess whether there's scorching that indicates a bad housekeeping program, or indications that would show where there's, rubbing on casings that would indicate bad preventive maintenance or something like that. That is typically how they're using it now. But this is kind of like anything, give an inch, and we'll see how many miles it ends up looking like eventually. Right now, it is only being used post-incident that I'm aware of. It's only being used after discussion with the employer, with the consent of the employer, but I don't think any of that is legally required. I don't know if any of you have ever had the experience where OSHA sits across the street from your facility for maybe even a couple of hours, videoing, photographing, before you even know that you're being inspected. This happens a lot in the construction industry. The idea is, if there is a place they're allowed to be, remember the plain view that we talked about? They're allowed to be on a public road, and so they're sitting on that public road watching your people work without, PPE or whatever it is that they're doing or not doing. The same thing is true for a drone. If that drone is allowed to fly, they get an FAA, flight plan. They are FAA approved operators of the drone. They don't need your permission to do that as long as they are staying off your property. So I think that is the next wave of OSHA inspections, is the drone flying around videoing you before you even had an opening conference. And they've been doing that for years in construction, where they'll set up across the street on a high rise and watch people not wear hard hats, not tie off fall protection, and do all that sort of stuff. But presently, they say the policy is with your consent and with notification to everybody who's on site so they can be protected from the drone itself. They will use it, and right now they're typically using it where somebody is not physically able to go. But I think this is just a new horizon.
And Eric, I would just say you want to consult with your attorney. Right?
Call your lawyer.
What sort of pickle are you in if you are on like a long-term lease property, adjacent to rail? Say you're a shuttle loading facility, and so you're not the landowner, and OSHA is working with the UP or BN. Do you have authority to not allow a drone?
I think you do. I think they're going to come to you for consent, and the idea is if your own employees are there, right? It's not my property, but I've got employees there. There's sort of two elements to that consent. One is that you've got a right to protect your employees, and then there's this notion that the drone flying overhead does present a hazard that wasn't there before the drone flew onto your property. And so that's a part of what the consent is about, is so that you can either remove people from the hazard or notify them about the potential hazard. So even if it's not your property, you probably will have some say into whether that event is going to happen. Of course, they can just suggest that you remove everybody from the site before they do it, so you have less control, but you should have a voice in the process, and could take advantage of that.
Well, great. Well, David and Eric, thank you very much. Appreciate it.